Nalin Kohli, lawyer, senior leader of the Bharatiya Janata Party, is joining me at this moment. Mr. Kohli, thank you so much for speaking to us. Let me ask you, sir, the court today has refused to take cognizance of the FIR filed by the charge sheet filed by the Enforcement Directorate based on the complaint of Mr. Subramaniam Swamy, once your own, now of course a pariah. But what do you make of this? Because, you know, the court very clearly, more or less says that the case doesn't stand proper legal ground. Isn't this an embarrassment for the Enforcement Directorate and possibly the opposition, the BJP as well, which was taking this case as a corruption case against the Gandhis?
It's neither an embarrassment for the agencies, nor can I consider it as part of the process, because actually the court has erred and it has not applied its mind to A, the law of the Supreme Court, and B, there's a contradiction in its finding. So let's understand. The ED would always act either on a predicate offense or on a complaint. There's a three-judge bench judgment of the Supreme Court, Vijay Madan Lal Sharma, in 2022 in para 191 clearly says that the ED, before undertaking an attachment, has to either there has to be an FIR or a complaint. Now, a complaint may be a private complaint or another complaint. So therefore, where the judge has erred, and this is certainly going to be challenged by the ED, I expect, as a lawyer, there's erred the judge by saying that, no, you can't take cognizance on a complaint or a private complaint because that is against the law of the Supreme Court in a three-judge bench. The second argument is the contradiction. On one hand, the judge is saying that you can't take cognizance because it's on a complaint. On the other hand, he says that because an FIR is there of the EOW, ED will subsume it. So, I mean, without prejudice, that's a contradiction, because if that FIR exists, then both ingredients are there. So I expect the ED to challenge it. That is for the ED to decide and its legal team. But more importantly, I'll be surprised if the Congress party doesn't challenge it, because if the argument that it will be subsumed, the ED will subsume the FIR or the FIR of the EOW, then the Congress is in deep trouble. So I don't know what the Congress is celebrating about.
Okay, but you know, the Congress and the opposition is using this as an example of how agencies are being misused, as court even refused to take cognizance. They are saying that, you know, on a private complaint, you have gone ahead and filed this case where the court today says that it doesn't even stand the proper legal scrutiny.
I think that's a convenient political argument. It's not based on law. And more importantly, this is not a discharge. This is not a certificate of innocence. This is a technical point that is bound to be challenged, and there's no reason why that this would not be overturned, as I just explained the law. So, I mean, if the Congress party is so interested in celebrating what perhaps is not even a minor hiccup in the larger context of things, let them celebrate it. But this is not a discharge. They may have a ground to celebrate if there was a discharge, but that seems very difficult given the facts of the AGL case, because the Associated Journal's press case has serious questions about young Indians. The fact that for no money, all assets worth hundreds and thousands of crores gets transferred to an entity controlled by the Nehru Gandhi family and its close confidants. And in effect, this is funds for public money or public purpose going into a private company, or at least in terms of its control, a completely tightly controlled entity.
But,
so I'm surprised that the Congress party is celebrating this.
But Mr. Kohli, that is for the court to take cognizance. These are the charges that the ED also made. In fact, in this case, at this moment, it stands, nowhere. But let me ask you this. Your opponents are saying, first it was the CBI based on the private complaint of Subramaniam Swamy, then came the Enforcement Directorate on the same complaint, and now because the the ED or the prosecuting agencies knew that they are on a weak wicket, Delhi police came in later. Multiple agencies being used, FIR now being in fact an afterthought to put pressure on the Gandhis.
Straightforward answers that are finally the Nehru Gandhi family members out on bail or not? Have they not faced problems in the income tax case? Have they been discharged anywhere? Is there a certificate of innocence? No. Every one of these questions, the answer is no. So, I mean, what is this about the explanation? The explanation from the Congress party on the AGL or the Associated Journal Press National Heral case is not convincing. Finally, let's put it in a different way. The Congress party is a political party. It's not a bank. Why did it give loans to AGL?
Okay.
I mean, what is it? You collect funds under the Representation of People's Act. You take an income tax exemption, and then you don't use these funds for political purposes, and you transfer it to a newspaper or an organization running the newspaper. Now, you may take the argument, oh, this is very close to Pandit Jawaharlal Nehru and the freedom movement. So the next question is, can the Congress party issue, for example, a loan to Mr. Rahul Gandhi or Mrs. Sonia Gandhi or Mrs. Priyanka Vadra Gandhi? Because they are, after all, the first family? No. So why then a loan to a company outside the Congress party, and on what basis?
Okay.
And how can you do that when you are getting exemptions under the Income Tax Act, and this is not permitted under the Representation of People's Act? Number two, then why are these loans written off? And three, why are they transferred to young Indians, which is in effect a Nehru Gandhi family entity?
Those arguments
So
now, of course, will be something that would be in the purview when it comes to the court. You've been, in fact, saying about this, and so has been the Congress party putting their side. But let me ask you, sir, my last question on this. When the court took cognizance of the... Mr. Kohli, if you can hear me, sir.
That is apparent in
Mr. Kohli, if you can hear me, sir.
Order that has been passed by the magistrate, and the revisional court clearly sees that the settle law of the Supreme Court has not been applied. Para 191 of Vijay Madanlal's judgment.
Mr. Kohli, if you can hear me, sir, when the court took cognizance of the IRCT case against the Lalu Prasad family, the BJP cheered about this and said this is prima facie a statement of their guilt. So when the court refuses to take cognizance in the National Heral case, should that be taken as prima facie innocence for the Gandhis?
You need to understand that eventually the question is, what is the judicial application, the application of judicial mind? And according to me as an advocate, there's been lack of that application in this order. There is apparently and clearly an error in terms of this order of the magistrate being actually against the settled law of the Supreme Court and a three-judge bench. Para 191 is the para, you should lead it or reproduce it in your program of this judgment. And the contradiction that is there in terms of saying that the FIR will get subsumed, the EOW FIR will get subsumed. So therefore, this is 100% going to move into revision. And that, of course, I must point out that the ED is very ably represented by the Additional Solicitor General, Mr. S.V. Raju, who's one of the top criminal lawyers and legal minds of the country.
Okay.
So, I mean, in fairness to say, if an error is committed by the judge, and if that's a source of celebration, good luck to the Congress. But I think the ED has a very, very strong case, and particularly in terms of challenging this order.